Kanu's defense continues as court adjourns. Case to November 7th. Counsel insists IPOB leader has constitutional right to represent himself. The ongoing trial of the detained leader of the indigenous people of Biafra, IPOB, Mazi Nnamdi Kanu, took a significant turn on Wednesday as the Federal High Court in Abuja adjourned further hearing in the case to November 7th, 2025. The adjournment is expected to give the separatist leader another opportunity to continue presenting his defense against terrorism-related charges brought by the federal government. Speaking shortly after the court session, Barrister Aloy Ejimakor, special counsel to Kanu, reaffirmed that his client has the constitutional right to represent himself in court, despite public concerns about the propriety of that decision. Ejimakor maintained that Kanu's choice to personally conduct his defense was deliberate, strategic, and within the bounds of law. A lot of people have raised questions and eyebrows about the propriety of Mazi Nnamdi Kanu representing himself. Ejimakor told journalists in Abuja, "It is his decision to make. He has the right under the Constitution to defend himself." Ejimakor commended his client's courtroom performance, describing it as confident and legally sound. According to him, the IPOB leader put up a very good defense during the session, which primarily centered on objections to the court's jurisdiction over the case. The crowning glory of today's proceedings is that Mazi Nnamdi Kanu has put up a very good defense for himself, he stated. Even though today's focus was on jurisdictional objections, he argued his points intelligently and demonstrated deep understanding of the issues at stake. The lawyer further explained that the adjournment until November 7th would allow Kanu to continue his defense when the court reconvenes. On that note, the court adjourned to November 7th for further hearing when it expects that he will enter his full defense, Ejimakor said. Ejimakor also stressed that the nature of Kanu's trial is deeply political, arguing that it cannot be treated as an ordinary criminal case. He said that understanding the political undercurrents surrounding the matter is essential to appreciating Kanu's approach and his decision to personally argue his case. This case being politically charged, the notion that this is a normal criminal case has to be dispensed with. This is not a normal criminal case at all, he emphasized. Drawing parallels between Kanu's situation and several landmark political trials across history, Ejimakor invoked the names of Nelson Mandela, Martin Luther King Jr., Obafemi Awolowo, and Mahatma Gandhi, noting that these leaders also faced politically motivated prosecutions and at times chose to speak for themselves in court. To understand the complexity and the true political dimension of this case, think of Nelson Mandela, Martin Luther King, Obafemi Awolowo, and Mahatma Gandhi. He explained, these were all politically charged cases masquerading as criminal prosecutions. At some point in their struggles, they took the podium and defended themselves. According to Ejimakor, politically sensitive trials often present unusual challenges that can limit the flexibility of defense lawyers, making self-representation a reasonable option in some cases. A politically charged case often comes with unusual dimensions, he noted. Lawyers are restricted to very narrow wiggle room, which can become prejudicial to the interests of the client when politics heavily influences the proceedings. He added that while the presence of legal counsel is generally advantageous, there are exceptional circumstances such as Kanu's current situation, where the defendant may be best placed to speak directly in his own defense. That limitation doesn't apply to the defendant himself. Ejimakor continued. Sometimes, the defendant will make the best defense of his case at that point in time. That doesn't invalidate the importance of a lawyer, but this is one of those rare exceptions. Meanwhile, during Wednesday's proceedings, Justice James Omotosho, who presides over the case, granted Kanu another chance to open his defense, but warned that failure to do so at the next sitting would result in the closure of his case. We had adjourned till today for the defendant to put in his defense or be deemed closed, the judge said. However, I am bound to give him another opportunity to present his defense. If he does not, I will deem him closed. I know that he is an economist and not a lawyer, so I will give him this last opportunity. Earlier reports by Sahara reporters indicated that Kanu had filed a fresh motion before the same court, seeking to strike out all pending charges and secure his immediate release. In the new court filing titled Motion on Notice and Written Address in Support, and dated October 30th, 2025, Kanu, who continues to represent himself, argued that the charges against him are a nullity ab initio, lacking any valid legal foundation within Nigerian law. He maintained that none of the charges were cognizable under the corpus juris of the Federal Republic of Nigeria. The motion, which cites several constitutional and statutory provisions, including sections 1-3, 6(6)(b), and 36,012 of the 1999 Constitution, alongside the Evidence Act 2011 and the Terrorism, Prevention and Prohibition Act 2022, forms part of his ongoing legal challenge against the federal government's prosecution. As the next hearing date approaches, anticipation remains high among observers, supporters, and legal analysts, many of whom are closely monitoring how Kanu will continue to handle his self-representation and whether the court will grant his motion to strike out the charges.